There's normally,
if you are being investigated, you are
the first
specific. And the judge says that the recent development means the present application is moot. There is no valid freezing order. There must be a freezing order.
You think everybody being investigated?
Please, what you are saying is not the case.
This is a ruling of a court.
I have it here.
It says there's no valid freezing order.
Bernard,
That concludes.
Bernard,
the judge says so.
Bernard,
there is no valid freezing order.
He's reading.
If he is rearrested, it's on a different distance. If he is, please.
At the time that this ruling was delivered, he had been rearrested.
Yes.
But you hadn't gone for any freezing order.
No, you don't need to, because you don't necessarily have to, because that Egyapa has administrative step has not been taken. And that would not be before the judge, because they may not have come to the judge.
Yoko was there.
What you are saying is that, as a matter of fact,
yes,
since the withdrawal,
yes,
there has been a new.
That is what they don't want to hear.
No, I'm asking you. Yes. Are you confirming?
Yes.
That since the withdrawal of those charges, yes, there have been a new.
Yes.
Whenever I say my PENDREAM TV there, I see them yopo.
A right perspective. It's important, especially as you have put it, a certain narrative as though the state represented by the AG is on a certain mission. So let's put the matter to the right perspective. Look, as my senior Egyapa said, the gentleman filed an application for leave to travel out on medical grounds. The reason you see the affidavit deposed to by the office of the AG to be affidavit in response was that the first day when the case was called, the AG had not even filed an affidavit in opposition. In fact, but the was in court, and the deputy AG raised issues that they are not in principle against his travel, but they want to see certain documents. And the document, of course, to prove that indeed he needed that services outside.
Oh, okay, now that clarifies it for me.
Yes.
That's why they intentionally didn't call it opposition. Okay.
And it is even here, when you read paragraph 5, you would see that they said that they are in principle not opposed. You read it to the
paragraph 5. The Attorney General is in principle not opposed to Hanan being granted leave to travel out of the jurisdiction for medical care.
Absolutely.
However, Hanan ought to provide the following particulars to enable the court to properly and effectively consider and determine the application. And then he brought those things.
And those are the things
the court granted him.
And on the day when the application was moved, the AG was opposed to those documents. I mean, the document, they thought that it wasn't really documents that of course they did. And then the court still ruled that he be granted. And that's where I feel the AG should have, because after I've also seen something, you've also seen the documents that Hanan presented to the court as basis for that application. I have issues with them. A lot of people are
questioning the judge's judgment.
No. I disagree with him, and I have that right. I disagree with the judge, respectfully. And I thought that the AG should have appealed. The AG should have appealed immediately.
So this is how to backdoor appeal?
How a backdoor appeal? No, I'm coming to the issue. Not at all. Okay. I'll deal with the issue. But I'm saying that, for starters, the AG should have appealed. Because these documents are not enough. Something with you've done this for a long time. Look at the documents you have. In fact, and it's good that I have to deal with it. It's important. One of the documents is a document from Makafo Eye Services Limited, to whom it may concern. Look at read the first paragraph. Mr. Abdul Wahab consulted me at this Legon clinic with the view of getting a referral letter. Is that how these things are procured? Is that how they are procured? This is the document he presented with the view to support his appointment with an ophthalmologist in the UK. Is that how it's procured? Look, these are the documents he intended using to procure the order.
He has an appointment with an ophthalmologist, but there must be a referral.
A referral.
Then he sees a doctor to say, yes, I have an appointment, but I need a referral.
No, you see, he is saying that he look, he had because if you read what the AG said, they required a document, an acceptable official medical certificate of diagnosis. It's never here. He never got that. This is not a diagnostic document. Do you understand? Something, because anybody can get this.
No.
Anybody, please allow me. No, anybody can procure this. anybody can procure this because it is not business as usual. He needed to convince the court that he needed those services outside the country. And this, for me, is not enough.
Kofi Bentil said it's enough if you read the letter in full. Is that not what you're saying?
Where does it say?
The last paragraph says, my impression is that Mr. Wahab has alleged conjunctivitis. I have explained to him that he is a qualified doctor. I have explained to him that this is not curable but controlled with anti-allergic eye drops.
Where is the diagnostic report?
Did you hear what I just read?
No, but this is not a diagnostic report.
I beg you, a doctor says...
So allow me. No.
Okay, so it's okay.
So
let's agree. He's challenging.
What's the form of a diagnosis?
He's challenging both the doctor and the judge. So let's go.
But I'm saying that I have a right to disagree.
What is the form?
Continue.
Let me continue. Now, so that is what happened. The court ruled. The AG didn't oppose. So of course, the man was at liberty to travel within the terms of the order. Now, this man from there goes to his bank. From the court, goes to his bank and presents a document to the bank.
A court order.
Relax, please. He presents a document to the bank. And the document for him...
We don't know how the document was presented, whether he went there or he sent it by email.
No,
so you said he goes to the bank.
The information I have is that he was there. Okay. That's the information at least.
I've heard conversations that suggest that he just sent it. You didn't have to go there.
Well, I know. I've also...
Okay, go ahead.
And then, you see, when he presented the document to the bank looked at it, of course, because the bank has received an order from the court freezing the account. And so if you go... And the bank...
Long ago.
And you see, the bank is not a party to the suit, the matter in court. They would not know whatever happens. So this argument that it automatically discharges and all that, no dispute. But how would the bank be in the know of what has happened?
You to be brought to the bank's attention.
Yes.
And so you, please. So you certainly have to bring a document to the bank to prove that there is a defreezing order. So the bank looks at it. First and foremost, the order that was served on the bank had a suit number different. You may say, do all the argument that they are in respect of the same case. The bank is not a party in the matter in court. So first, the suit numbers are different. Secondly, there is nowhere in the ruling of the court. This is not an order anyways. Let me put it this way. It is a ruling of a court. And Sam, you agree with me?
What is the effect?
Oh, the effect, yes, but we've been using this. We are doing.
Go ahead and make your point.
I'm saying that when the order, this document was brought to the attention of the bank, and I state here that there is nowhere the court refers to any account number. In fact, when you read the first paragraph, the court deals with the 4 items that were in the order for the freezing, as in the Identity High Court that he went. The court never mentioned any bank account. But you see, I haven't read this ruling. The judge is a very smart judge. Why didn't he grant the order but had this struck out?
Grant the order?
No, but the
because
order...
he was telling them that
yes,
you have come to court for something.
Yes.
But the thing you are coming for, you don't have to come for it because the charges have been withdrawn.
So relax.
And since the charges were withdrawn, everything that was done on the back of those charges have gone with the wind.
Hold on, let me deal with certain things he said.
All right.
The judge, yes, as has been read, the judge said this. He said it is common knowledge that the applicant has since been rearrested. Don't forget the Yoko law, the Yoko law, that is it? Yes, section 33, which gives the Yoko some orders without even going to court and freezing. They have that right, but after they are done, they have to within 14 days.
So finish reading it and make the point.
I'm reading it. Yes.
It is common knowledge.
So it is common knowledge that the applicant has since been rearrested. The development has a direct effect on the present application because the withdrawal of the charges against the freezing order has automatically discharged. It was automatically discharged. The rearrest begins another process as the applicant ought to be cautioned and charged with an offense. The first thing we should ask is that, was he, after the discharge of those charges, after it was withdrawn, was he rearrested or not?
Yes, he was. Mm-hmm.
Do we know what he was taken through? I am aware that he was placed on investigation and he knows it. So,
go on.
So the judge is saying that the rearrest begins another process as the applicant ought to be cautioned and charged with an offense, which was done. The caution statement taken from him on the 26th of June 2026 is no longer in force. And which is true.
It's no longer enforced
to trigger investigation and possible charges because it's been withdrawn. So the judge, yes, it's true. There cannot be a freezing order in respect of a property where no investigation or prosecution is ongoing. So the judge is a smart judge. But you should ask yourself whether there was an investigation ongoing. Yes, there was. When he was rearrested, he was taken to Yoko. So the judge is saying that on what you brought, there is no issue. Because if there is no investigation ongoing, it is automatic. But if there is, then this doesn't apply.
If you were in private practice,
yes.
Still,
yes.
I don't know if you still go to
Yes, I do.
Okay.
Yes.
And Abdul Hanan was your client.
Yes.
Would you have interpreted this decision the way you are doing?
I agree with you, but if you were also the Attorney General,
would you not have told your client that you need to bring this decision to the attention of the bank, that the freezing orders have been discharged?
Samson, if that is even where I, with the greatest respect, fault his lawyers. Look, what he should have rather sent to the bank were probably court notes in respect of the charges on the, that particular, the account thing, or that day when the charges were withdrawn. The court note would have served him better. Because this one is in particular in respect of 4 properties which does not include an account.
The value of
there is.
When you have a court order.
No. Which court order?
You have a ruling.
Which court order?
You have a ruling. Read all the necessary parts.
Where?
Okay.
Where? Tell me.
It says that there cannot be a freezing order in respect of property.
Is that what I read?
No, you didn't go there.
Oh
wait. Where no investigation or prosecution is ongoing now, an investigation or prosecution is not equal to.
He disagrees. He disagrees.
No, I disagree.
He disagrees that there cannot be a freezing order when investigation is.
Here's the point. Please, then let me make a small point.
No. Bernard, you have a bank account. You're not listening to me. I'm saying that you are making the contrary point against what the judge said.
Yes.
From where you said the judge is wrong on that point.
No, the judge is not wrong.
My point is
no, the judge is not wrong.
I think it's an important point. You can be investigated for so many things. Doesn't mean your account is frozen. To freeze your account, there must be a specific motion for that.
Not
be granted.
No.
There's normally,
if you are being investigated, your account is not automatically
the first one. This
is specific. And the judge says that the recent development means the present application is moot. There is no valid freezing order. There must be a freezing order. You think everybody being investigated?
Please, what you are saying is not the case.
This is a ruling of the court.
I have it here.
It says there's no valid freezing order.
The
judge says so.
Bernard,
there is no valid freezing order.
He's reading the very last paragraph.
Look at that. Is there? The judge says so.
This recent development renders the present application moot. For there is no valid freezing order in the first place following the withdrawal of the charges against Abdul
Hanan. Samson.
The application is therefore
so why can't he take this to the bank and say no.
Please allow me to develop my point. No. Please allow me. I am saying that there is the administrative power.
Freezing.
So it is not the case. Senior Bentil is not correct here. It's not the case that at every point in time you need to go to the court to procure an order. It's not true. You can do that. The Yoko under 33(1), they can do it, but within 14 days, they have to. And I'm saying that there is no dispute as to whether the charges were withdrawn. And the judge is operating on the basis that those charges under which you are before me have been withdrawn, so you don't even need to come. But the judge said if there is no pending investigation, I am aware that after the charges were withdrawn, he was rearrested, put on another investigation, and he was informed on what is available and what is not available. And so for me, if that was how do you call it? That charge was on him and he was being investigated, and the Yoko officer, as I'm hearing, freezed the assets from there. Then the Yoko under the law of the Yoko, the 804, it kicked in. What they should have probably done, beyond the freezing, maybe within 14 days, they ought to go to. So if they are saying that there was no freezing on the order because the charges were withdrawn, that is a fact. And the judge smartly said that if that is not there, then the reason you are before me.
Guys, I think you should listen to Bernard a bit here. He saes that when the judge says, wait, hold on. When the judge says there cannot be a freezing order in respect of a property where no investigation or prosecution is ongoing, what the judge was suggesting here, according to Bernard, is that for as long as there is ongoing investigation, there can be a freezing order.
Respectfully.
But again, how do you marry that with the final statement in the ruling, where the judge says these developments render the present application moot because there is no valid freezing order in the first place?
So something simple. The answer is simple. It's express your units.
Kofi.
It's express your units.
This application was not ex parte.
Which one?
Bediako was there. The respondent is represented by Rabiatu Abdullahi with Ebenezer Jiman. So Bediako was there.
Samson.
So it is not a matter that you can say that the judge was making statements out of 10 in the absence of the relevant parties. Both the applicant and the respondent were in court, represented by counsel. What are you talking about?
Samson, I am saying that there is nothing.
But you said it. Samson said it for you.
Please.
We were responding to Samson. He was speaking for you.
I listened to you. I have a few other things to say. Please, allow me.
You let him finish.
Let me do. Okay. There is nothing wrong with what the judge said.
Okay.
There's nothing wrong with it because the judge premised it that if there is no ongoing investigations, then you are before me for nothing.
How do you reconcile that with the final?
No, but the final is always based on, we all read judgment. It's on, because the judge is saying that you are before me and you've exhibited a discharge, whatever, that the charges have been discharged. If it's been discharged, then it's moot. But if there is an ongoing investigation, of course, the judge will not continue on that tangent because he's not.
So why strike out the application?
The judge said, the reason the judge said the application is moot is that for there is no valid freezing order in the first place following the withdrawal of the charges against Abdul Hanan.
So if he is rearrested, it's on a different if he is, please.
At the time that this ruling was delivered, he had been rearrested.
Yes.
But you hadn't gone for any freezing order.
No, you don't need to because you don't necessarily have to because the Yoko has
step has not been taken.
And that would not be before the judge because they may not have come to the judge.
Yoko was there.
What you are saying is that as a matter of fact, since the withdrawal, there has been a new.
That is what they don't want to hear.
No, I'm asking you. Are you confirming?
Yes.
That since the withdrawal of those charges, there have been a new.
Yes. I am telling you, by Yoko,
Yes. The withdrawal was done when, and if we know the date of the withdrawal, we will know whether it has been time for them to go for a confirmation.
That's a different matter. If they don't, if they haven't, you won't say there's not been a freezing order. You will go to court.
But if you don't go for a confirmation,
what you did also will have to go to court and then seek to set aside that order because for lack of maybe refusing.
Can I also say my one small thing?
But you cannot say there's not been a freezing order.
Can I say my one small thing?
Please allow. You've said your own.
The withdrawal was made on the 5th of May 2026.
Okay.
So if there is a new freezing order from the 5th of May 2026, there would have been a confirmation.
Thank you.
And I'm saying that if they haven't
which will not be known only to Iyoko privately.
Thank you.
I'm saying that if they haven't done it, the solution would not be to say that there isn't a freezing order at all.
Finish your point.
I beg, people must know something.
We need to
There's something called express your units.
Allow me flow.
The expression of
you talk a lot and then you forget yourself that you have been talking.
Because they are all over me.
Kofi, go on.
When I heard you say all that, you said that you didn't allow.
The expression of one thing implies the exclusion of other. It is said here, it is moot, there is no valid freezing order. It cannot be that there is. 1. 2, if you are being investigated, it does not mean automatically your account have been closed. 2, if your accounts are going to be closed, that thing must go before the judge must agree, and then it is closed, and you must know. It is not ex parte, it is not a secret. Okay, so, and the last point, what is implied can never overrule what is expressly stated. Okay, We have what is expressly written here.
Stated.
There is no evidence that there has been a new order freezing the account.
Yeah, so Kofi, you see what he's asking, what he's saying is that administratively they would have done some, but it is not known. But the point that raises is that Iyoko was also in court over this matter.
That's the point. That's why.
So did they tell the court that there was a freezing order? If they had told the court that there was another freezing order administratively, can the court make a pronouncement and say there is no one?
Iyoko told the court that.
So can I also make my point and finish? Because you are trying to help me now. So he is implying.
No.
I beg.
I'm not implying.
Show me the order that says there has been a new freezing of the account.
He's implying and assuming.
Oh, something. And I'm saying when we have a court order in front of us,
even
that says that the old is dead.
If that order in writing,
you are telling me that implying?
Why did the Attorney General exhibit it to his new application?
And my last point.
No.
Yes, the Attorney General did not exhibit it.
In what?
Yes, the new application for revoking the leave.
The leave. Yes.
He would have added that since the withdrawal of the charges, there has been, as you say, a new freezing order.
No, but who is disputing it for the AG to file something to that effect? Who is disputing?
Because the judge has said in the ruling that there is none.
No, but the judge operated on the basis of these 4 properties, which has nothing to do with whatever may have been said. It's in respect of the 4 properties. No, read this. So I
didn't finish what I had saying that if you were the Attorney General,
yes,
and this matter came up and you were going to court for a revocation, and you know that there will be, it will turn on this interpretation.
How would
you will still not exhibit? Wait, you will not exhibit that.
Where is the order?
Yes, there may be. If they
later. So say that when you say a supplement, that's different. That you file later.
But at the moment, there's no dispute.
Okay,
if they file the liberties of a Ghanaian citizen,
they filed this only 2 days ago.
You said what? So they should respond and say there is no freezing order. Then the AG, if there is, would file a supplement.
Okay.
But at the moment, there is no dispute. Why is the dispute that there is no freezing?
He's landed. I'm being asked to take a break.
That was the evidence before that.
No, it is in respect of these 4. And I still submit.
Even if I have said that the implied cannot overrule the express, we have the express. He hasn't shown us every evidence.
I said,
even if the evidence, please, even if the evidence existed, okay, Hanan is fully within his power as a bona fide person without notice to go to the bank and say, I want my money.
Oh, I get that point.
And let the bank produce that other one. So how do you arrest a man, okay, who has no information, even if what you are implying is true?
Get that one.
Yeah, I get that one because in the bank refusing him, that we have said, the bank would have informed you that there is actually a new freezing order. If you are saying that there is a requirement of a new freezing order and same has been issued, the bank would have said so.
I'm missing the point. The bank is not party to what happens in court.
Yes, but when a party comes to tell you and say that the freezing order has been discharged, you will tell the party that there is a new one.
No, Samson, what the bank holds or held all this while, assuming there is even no new freezing order, will be the old one. You are in court doing your thing. If you come to the bank and you seek to vacate the old, even the older, you should show the court, the bank, what you have to vacate what they have already.
Which is the court order?
No, the court order, they saw a lot of things because it has nobody.
The court order is
thank you. You were raising an angle around the Abutrika. What can you say briefly about that? Who was raising an angle?
Yeah, I was.
Yeah, okay. What did you mean?
That, if what we're hearing, because I'm not particularly seized with the entire facts.
That he has been extradited.
Yes, that is a notorious fact. I mean, we've seen the videos, we've seen the tapes and all that. But what his lawyer is purporting to have transpired prior to his extradition, if indeed those statements are true, then really, Dominic and Ṣháme, please, it does not.
What would they have done wrong? Please help us.
Of course, I mean, the guy is alleging that all attempts to serve the processes for habeas corpus on the Attorney General, going to court ex parte, the court saying go on notice and all that.
And there's supposed to be some stay off of sorts.
And all was calculated to, deprive the gentleman his day in court, and he was bundled and sent away. I don't think it's proper, and So the Attorney General and his deputy.
So even if there would have been extradition, it should have abided the court hearing the matter.
Absolutely. Without
Kofi, why are we acting surprised? By my checks, this is the first time that the extradition of a Ghanaian to the US has suffered this kind of delay, where a lawyer goes to court and successfully gets a situation where the guy is not extradited. And it's been how many months since he should have been extradited?
The Susudis case, some of us are old enough to remember the Susudis case. It didn't go this way. They exchanged him for many more Ghanaians. All right? So please, this is not. If what we are hearing from Oliver is true, then the Attorney General surrendered our sovereignty as a country. Because effectively what it means that they overrode our court, they walked roughshod over our courts, who were seized with a matter and took orders from another country and sent a Ghanaian citizen out to some other person. It is a surrender of our sovereignty, no matter what that guy did. You should never do that. Look, me, I'm a proud Ghanaian, all right? And for whatever it is worth, if you don't have anything at all, you should have your country behind you.
Please, we are dealing with the USO.
So?
You're talking Garrett and whatever. They are the ones giving you money for a lot of things.
Then we don't have any
sovereignty. You are poor.
Garrett is a World Bank loan.
We don't have anything. On a lighter note, somebody sent me a joke and said, if Oliver knew they were going to extradite him, he would have gone to take the key of the plane.
Of the personalities involved at the Attorney General's office. Dr. Dominic Aini was my professor in the law faculty. Stremsai and I worked together on some case for a client of ours, and so I know him personally. I know their competencies. I know their position on the rule of law. And for the first time, I stand corrected, 2 law professors occupying the office of the Attorney General and Deputy Attorney General. We who know them professionally, and even the public, I suspect, expected that they were going to be, that fidelity to the rule of law was going to be what would guide their actions. But the happenings in the Attorney General's department, personally, leaves a lot to be desired. This matter regarding Hanan, and I've taken pain, liberty to go through all the processes. And I find it rather worrying that under the aegis of the Attorney General and the Deputy Attorney General of the Republic of Ghana, an order of court granting leave for an accused person to travel out of the jurisdiction will be handled in the manner that it was handled. Indeed, if it was an ex parte application, then you would probably excuse the AG for the arrest, But this application and the order pursuant thereto was made on notice. Hanan filed the application for the leave to travel on the 12th of June 2026. Motion on notice, application for leave to travel out of the jurisdiction for medical care. This was duly served
because he's on bail and his passport is in the custody of the state.
And so he needed the permission of court to travel outside. On notice to the Attorney General, the Attorney General's office filed an affidavit in response on the 24th of June 2026 and canvassed essentially some reason why they felt that the order should not be granted. They were of the view that in respect of some averments that had been made, an acceptable official medical certificate of diagnosis ought to be provided. Again, they were of the view that a certificate of record of previous instance of medical care ought to be provided. And in respect of some averments they were of the view that an acceptable certificate of medical appointment in London ought to be provided. This is the affidavit in response to the application.
In opposition.
In opposition, if you like. But they headed it affidavit in response. That's why I'm using their own words.
So let's cut to the chase. They lost their point. The judge didn't buy their point and granted the application for
it's important. It's important. I mean, I know that you are managing time, but it's important. Hanan then filed a supplementary affidavit and provided additional information to satisfy the issues that the Attorney General's Department had raised. A date was fixed for determination of the motion. Oral arguments were taken, and the court, after listening to both parties, then granted leave for Hanan to travel to the UK and seek the medical care that he so required. He goes to the airport, and for some strange reason, he's arrested. The Deputy Attorney General announces on his Facebook post that law enforcement have a while ago arrested Hanan, who is currently standing trial for stealing and causing financial loss, blah, blah, blah. It was, however, Mr. Aludiba's attempt to use false means to empty his frozen bank account with the Republic Bank on Thursday, which occasioned tonight's arrest.
That is to say, a new crime is being committed. That's why they have arrested
according
him.
to them. Now, subsequently, the Attorney General files a motion for an order to revoke the leave that was granted to the first accused person to travel to London on dated 29/06. So expectation would have been that that attempt to empty his bank account would be what the Attorney General canvasses in his
main argument
application as the reason why the order of court ought to be vacated. Sadly, the Attorney General seemed to be re-arguing the application for the leave that they argued, pursuant to which the court granted leave for the accused person to travel. So I asked myself, they do not provide any evidence of a check that had been issued by Hanan on Republic Bank to withdraw the funds from his account. They do not provide any evidence of a letter that Hanan had written to the bank authorizing them to transfer the money to another account. They do not provide any evidence of an email or a withdrawal slip. So I asked myself, what is the basis of the assertion that the gentleman attempted to empty his account? The reason why a lawfully issued court order will be trampled upon in the manner that the Attorney General's office did when the gentleman attempted to travel out of there.
And remember, their main point is that this account is frozen, so you are not supposed to touch it.
But then again, that in itself is questionable.
But first,
because
you are holding the affidavit that they have filed, the application together with the affidavit, and you are saying that the reasons that Justice Ramsay gave on social media about an attempt to empty the Republic Bank account is not made.
Yes.
Not at all.
They only mention that A1, which is the accused person, submitted an order of court to the bank to suggest, if you permit me.
It's okay to look for it and read it.
Let me just read it. Okay, I thought I highlighted it. So Hanan had.
Once you are doing, let me look for the specific paragraph.
Yes. Hanan had, in a previous matter which was determined by the High Court on 20th of May before His Lordship Justice Kwame Jan Osei had sought for the court to vacate the order freezing.
Let me read the specific paragraphs before you go there. They said that subsequent to the court's travel leave to him, after he had been granted leave to travel, Hanan attempted to withdraw all the money in the bank account, notwithstanding that the freezing confirmation orders on the bank account remained undischarged. To achieve the purpose of withdrawing all the money from the said bank account, Hanan represented to his bankers at Republic Bank that the prevailing court freezing confirmation orders on all the bank accounts had been discharged by the High Court, a final one. The document which Hanan presented to his bankers as the basis for his representation that the High Court has discharged the freezing confirmation order is a court ruling in an entirely different matter, namely suit number so and so, May 20, 2026. Please go ahead.
You see, Samson, that assertion comes to me as extremely strange. Recall that Hanan was arrested and charged. When he was arrested and during the investigation, the investigators issued freezing orders by the executive director of EOCO, multiple occasions. And those multiple occasions required the confirmation of court on multiple occasions. And so the freezing of his accounts required that they go to court to go and confirm. That will require a suit number. The freezing of his property will require that they go to court for confirmation. That will require another suit number. But all those different suit numbers related to the same investigation based on which he was charged. Now, the Attorney General discontinued that charge.
Right.
So Hanan, thinking that that freezing order was still in place, then goes to court to seek the court to discharge his properties. This is what the court, after evaluating the fact before it, said.
Right.
The court said that indeed the applicant was cautioned on 30 June 2025 and the administrative freeze was issued on 29 August 2025. This is in respect of the properties that are listed in the application that Hanan brought to court.
Okay.
It is common knowledge that the Attorney General has since 5th May 2026 withdrawn all the charges against the applicant.
This is the court speaking.
This is the court speaking.
Okay.
Leading to his discharge by the High Court Accra. It is also common knowledge that the applicant has since been rearrested. This development has a direct effect on the present application because following the withdrawal of the charges against the applicant, the freezing order was automatically discharged. Question is the freezing order in issue restricted only to the matters that he had applied, or it applied to all the freezing orders in respect of the charge that had been leveled against him?
Okay.
He took the position, or his lawyers take the position, and I agree with them, that by this general principle that was established by the court, all freezing orders affecting his property, including his bank account, had been discharged by reason of the Attorney General discontinuing.
The judge's use is not just discharged, automatically
absolutely. Yes, because there's no case.
Go ahead.
And all actions that had been taken or all orders that had been given by the court pursuant to the original charge which had been discharged, all those actions go
falling out
completely. Now, if you recharge him, you need to go back to court to go and obtain another order freezing his
This they didn't do.
They
from your point of view.
They haven't. So the court continued that the rearrest begins another process as the applicant ought to be cautioned and charged with an offense.
Right.
Then he proceeds to say that there cannot be a freezing order in respect of a property when no investigation or prosecution is ongoing. The court concludes, this recent development renders the present application moot. So the court is essential for there is no valid freezing order in the first place following the withdrawal of the charges against the applicant. The application is therefore struck out. So the court essentially said to Hanan that, look, there is no order pending before me for you to ask me to discharge, because with the discontinuation of the charges against you, all the freezing orders relating to that charge has lapsed. Hanan then breaks this order to the notice of his bank without more. He didn't issue a check. He did not send any emails. He did not issue any withdrawal slip. How is bringing this ruling of the High Court to the attention of the court?
Are you sure about that?
So yes,
in the affidavit by the Attorney General, they say that after he sent them the document, they say that alarmed by Hanan's obvious misrepresentation, Hanan's bankers refused Hanan's request. What request is that? And immediately informed the Office of the Attorney General and the investigators at the Economic and Organized Crime Office of Hanan's efforts to, by false means, empty his bank accounts.
Where is the exhibit evidencing that? Because it would seem to me that if the Attorney General is alleging that Hanan indeed attempted to empty his account, he could only do so through formal means. Either a check drawn on the account, either a withdrawal slip filled to withdraw money from the account, or some instruction of sorts. Did they exhibit any such document to the affidavit?
What is the...
No. Let's deal with that before you...
No, they haven't. They haven't. What is the intention? What is the intention behind Hanan taking the court order to the bankers? The court order that says that all previous whatever have been discharged, they have fallen into whatever. So the Attorney General need to do things fresh. What is the intention?
But of course, his accounts have been frozen. His assets have been frozen. He's gone to court for a discharge of some assets. The court informs him that, well, as far as I'm concerned, that is the court, there is no freezing order in place. What is wrong with he bringing that to the attention of the bank that holds his accounts that has been frozen?
Okay.
What is wrong with that? But the Attorney General goes further to make subsequent allegations without providing any evidence to support it. And now they go back to court with this application, seeking to relitigate the matter that the court of law has pronounced upon. Something is worried. And I beg of my good friends, a lot of us have high regard for them. They being me, I'm an MPP man. Okay, wishing for Dominic or Sremsai's removal will not lead to me being appointed in their place. I wish them well. But the office that they hold enjoins them to act in a certain manner. It is not only this, I'm sure we'll come to the Abu Trika one. And you've seen the write-up that Oliver Barker-Vormawor has put on social media.
About the state being abusive and disobeying court orders.
It's worrying.
Okay.
Especially with the kind of petty
I'll bring Bernard in.
Have.
Thank you. I'll bring Bernard in. But let's Kofi come in. Let's Kofi come in here. Kofi, so what do you see?
Look, what I see is a worrying trend. A worrying trend of the might of the state being deployed against one person in a crude manner that nobody.
Not to interrupt you. Don't you feel that the Attorney General has a sense that in the previous regime, under Godfrey Dame, many of the people standing trial got the same kind of permission to go for treatment abroad, counting from Sedina, Tamaklo, Opuni. There was that man who was standing trial with Atoforsen and Japa, who was eventually, as it were, Animana, who was eventually, the case was discontinued against him because his health was failing him. Don't you feel that they have a sense that we can take lessons from that history? That when these people get disorders and they go out, they say, we are going, we'll be back. They may not come back.
The point is, if that was their fear, then at the time when the man applied to the court for permission to go out, they should have said that. And they should have taken steps to stop that. And by the way, we have bilateral relations with other jurisdictions. There are all kinds of ways of making sure. That is when I come in and say that, look, we should focus on the things that matter. So specifically on the point you are making, if your fear is that the person will abscond, there are all kinds of other ways to prevent it. Okay? Now, what they did was not that. They actually went and arrested the guy at the last point. They could have arrested him on the road before he entered the airport. They could have arrested him the day before. They wait for the guy to get into the airport, about to embark, and then you arrest him, okay? And then the charge was that he was trying to access his own account. So it is not what you
His own account that has been frozen.
Wait, I said his own account because at the time, there was a discharge on the thing. The basis upon which the account was frozen had been vacated. And there was an order to that effect with the judge. That is what Egyapa read. So
that's right.
Expressly stating that there is no issue against him. So everybody would take that to the bank and say, this is my discharge letter, give me my money. It is for the bank to say, hey, I haven't been told, so wait. Or for somebody else to raise anything, but he has no problem whatsoever in presenting that to the court. So for somebody to raise that as if it is a crime, it's worrying.
Attorney General is saying in court that when you went to court for the discharge, you went to court for the discharge in respect of your properties, not the bank accounts. It's a comment, which is actually judicial ruling, that says that affects your bank account. You don't bring that one, which is about your property other than the bank account, to want to give an impression that your bank account has been unfrozen.
So what you're saying, I know what you're saying, but let me explain it also to the public. You go in to buy one good. The owner of the good, the person who has authority, says that take all the goods. So you take half of the goods and leave the other half. Somebody catches you at the gate and says, you came to buy one, why are you carrying four? You say, oh, the man said I should take all. That's what has happened here. You go in, and the judge makes an express, when you said a comment, it's not a comment. This is a ruling of a judge.
I qualified it later.
Yes, yes. It has the force of law. And it says that there is nothing before me. All these issues that you are referring to and the things that come with it, they are dead. He used the word
automatically lapsed.
Automatically lapsed. This is a layman. Even for us lawyers, that is sufficient authority to present before the bank. The bank can say, I haven't seen it. But there is no problem presenting that before the bank. And the point I was making when that came in was that, so when the learned Attorney General, and like Egyapa said, these are our friends and colleagues, we know them, they are good lawyers. When he goes and says that constitutes a crime, it is worrying. It is worrying because it is either extreme sloppiness in terms of appreciation of the law and the issues, or it is malicious. And like I said, they could have arrested him on the road. They could have arrested him at 37. They could have arrested him in front of the airport. You wait for him to clear, and when he's going, you arrest him. My worry is that if it happens to Hanan, it can happen to any of us. And look, in MPP time, like you're saying, you saw similar things. My question is, when is this going to stop? And who is going to be the next? The point I started with is that no matter who you are, even if you are the president today, if the powers of the state are arrayed against you in this manner, you will suffer. So look, we should get to a point where we stop these things. This man, okay, has been arrested 3 times. And when you have that situation, look, at West...
This time he spent 4 days.
4 days?
Previously he spent far more.
Okay, 4 days. And let me make this point. Look, no complaint of sickness is unserious. no complaint of sickness is unserious.
The times he has complained of being sick in Iyoko, they have attended to him. They've taken him to hospital.
No complaint of sickness is unserious. Somebody can say, I have a headache. In 3 hours, he will be dead. Okay? In March this year, in Arizona, a man who was in ICE custody complained of a toothache. I have his name somewhere. Emmanuel Damas. Google Emmanuel Damas. He complained of a toothache. And the ICE people refused to take him to the hospital. He died. And when they checked after he died, they realized that the thing was infected. And the infection killed him. The point I'm making is, when you keep a man who is complaining of sickness for 4 days, you are putting his life at risk. Look, no matter what people have done, and by the way, when it comes to buffer stock, when they started buffer stock, I complained about it. So some of these things, when we talk about them, we say you are defending the president. No, it's a different matter. Okay?
They arrest him,
yes.
And the lawyers go there. The BNI people say, we don't work on Sunday.
But they were able to arrest him on Sunday. And by the way, when it comes to human rights and habeas corpus, as in keeping somebody, Sunday is also a day. You can die on Sunday. So that point, you see, sometimes the lower level guys say things which the upper level guys know are not true. So look, I was saying this looks like an abuse of state power. And that's what worries me. Because the learned Attorney General and his deputy know the law that we also know. And if it's an abuse of state power, where will they stop? At the best, if it is not even an abuse, it is a very botched prosecution and process. Because they have what we have here. And if this is going to go on, and Egyapa comes into office next time, is he going to do the same thing? I suppose not, I hope not. Because it must stop somewhere. Accused persons must be allowed to go through due process, must be given sufficient rights to defend themselves. With one person, the whole state comes up against him once. They don't go forward, they are not able to go forward, they didn't do their homework well, for some reason, then they drop. Then they leave the man. The man should be able to continue with his life. Then you arrest him again. You go through the whole thing, you make mistakes or whatever the reason is, you drop all the charges. Meanwhile, you've held his account. The man is sick. He wants to go out. Now they are saying Boots is not a hospital or whatever it is. I beg, please. Then you go for him the third time. On top of that, you arrest him in the airport. It's harassment. It is harassment. And it must stop somewhere. Look, somebody commits a crime, jail him, prosecute him, send him through the due process. Then we'll all be fine. Because what is going on now, we don't know what the truth is. Is it really true that
this is a man who has 78.2 million on his head?
Yes.
The state must be careful not to give him the opportunity to slip out and never come back.
Careful not to give him the opportunity means do your investigations well, don't strike 3 times. Careful not to prosecute him means that when you are going, be sure, because you have the whole state behind you to do all these things. You go once, oh, sorry, then you drop it. Then you go twice, then sorry. Meanwhile, his money is, held up there. So yes, you must be careful. In your care, we lawyers know, they say it is better for 1,000 guilty people to go free than for one innocent man.
99.
Yes. So please, we are not saying don't do your work, but the evidence on this, 3 strikes, holding his account, preventing him from traveling, putting him under all this stress, it's not prosecution. It is execution.
Bernard, there are people who feel that Hanan Aludiba is being unfairly treated, particularly the times when he has suffered detention. In the first situation, I don't recall how long, but it was so long. He couldn't get out on bail because the bail, once again, you remember the accusations of weaponizing bail, and bail is not supposed to be punishment according to law. And yet he was held for so long. Then the second time, again, he had to suffer for quite a bit in custody. And then this third time, he spends 4 days. People are asking, if you could release him and let him go, like you did on the 4th day, why did you have to wait until the 4th day?
I'm not PENDREAM TV. Now, so far so good. Say open online portal in Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.